Commercial lawyers build structures for asset protection, tax efficiency, and succession planning. But those structures are rarely stress tested against separation or divorce. Unfortunately, years of drafting experience mightn't be enough for the structures to repel such eventualities. Under the Family Law Act, the court has jurisdiction to alter property interests of married and de facto couples, including those held by third parties like companies and trusts. The question isn't legal ownership, it's two things. Is it property or is it a financial resource? If it's property, it goes into the pool and gets divided. If it's a financial resource, it influences the percentage split. Either way, your structure and its value is in the balance sheet for consideration. The critical concept is control, not title. If your client is the appointor, the default beneficiary, or the one who has decided historically distributions, the court may treat that trust as theirs in all but name. In Kennon and Spry, the High Court went further. The wife's equitable right to due administration of the trust and her right to be considered for distributions was held to constitute property of the parties to the marriage. And it doesn't stop at trusts. Private business interests attract valuation disputes, net asset value versus capitalised earnings. Excessive drawings, personal expenses paid by the company, or pre-separation asset stripping can be considered as wastage and influence the final percentage division. What looked like legitimate planning under the Income Tax Assessment Act can look very different under cross-examination. There's also third-party exposure. Under sections of the Family Law Act, courts can make orders binding on corporate trustees and third-party entities, meaning your corporate client could find itself joined in another party's divorce proceedings. So what's the practical takeaway? Binding financial agreements remain the most effective preemptive tool. But if your client is already separating, advise them clearly. Don't touch the trust, don't restructure, and do not adjust distributions without specialist family law advice first. Post-separation conduct is scrutinised heavily, and what looks like ordinary trustee discretion can be characterised as dissipation. The structures we build are only as robust as the legal frameworks we account for. Family law is one area most commercial advisors overlook until it's too late. If a client needs to have a discussion about separation or divorce, please contact me for an initial no obligation conversation.